Okay, so we left off in our last video, we were talking about disqualification, and we're going to come back to that, but we're going to kind of go off on a tangent for a moment and talk about remedies. And sometimes one way to think about legal rules, not just for professional responsibility, but for any of your classes, is to look at the end consequence and work backwards. So in law school, we tend to teach you the rule, and then maybe at some point down the road, we teach you what happens when somebody violates a legal rule, like your constitutional rights or your property rights or your contract rights. So we spend a lot of time teaching you about the rule up front. And then sometimes it's an afterthought, or at least it's a later point at the end, because it's chronologically comes later, to talk about the remedies or the damages or something like that. As a law student, it can really give you a lot of insight about a rule, to do a thought experiment and start at the end and revert and walk backwards. And just so think about the consequence and walk back about that. And it can change the way you think about a rule sometimes. And one of the reasons for doing this is that rules aren't all enforced evenly, right? And they're not enforced exactly the same way. And so you may have noticed as a law student, when you're talking to non-lawyer friends, something comes up and you're like, yeah, you can't do that because it violates someone's constitutional rights. And then they think, which means that the other person will go to jail, right? Well, not necessarily. It may be that the remedy is injunctive relief, right? Or you have people that the remedy may be a civil remedy, like you sue them and you get damages or something, but they have in their mind, you hit me with your car, or you trespassed on my property, therefore you should have to go to jail. And they don't understand, because they're not lawyers, that not all legal redress is done through the criminal justice system. Or conversely, there's certain types of cases where there's only injunctive relief available, and people imagine when they come to see you as a lawyer that they're going to get millions and millions of dollars when they're not. And so let's think about it this way when we look at the model rules and the lawyer ethical rules, because the rules are not all enforced the same way. Now, on the MPRE, almost all of your questions are going to say, was it proper for the lawyer to do this? Could the lawyer be subject to discipline? And what they're talking about there is the state bar disciplinary authority, which some states call their grievance committee. Other states just call it the state bar. And some call it their disciplinary, the lawyer disciplinary office or something like that. We call it the Office of Disciplinary Appeals, or disciplinary counsel. And they kind of have three remedies that I have here. And I have them listed with the most severe, which is disbarment, and then suspension, and then a reprimand. And so obviously reprimand is the least serious. This is a slap on the wrist. And there's two types of reprimands. You can get a public reprimand where they're going to publish it on the State Bar's website. Attorney Stevenson did this, and we've kind of rebuked him. It's like getting censored, by a legislative body or a tribunal or something like that. So they put it in your record and they tell the world about it. Or they may publish it in, let's say, the Texas Bar Journal. A private reprimand, they just put it in your file at the bar so that if you get in trouble again, you already have one strike against you, but they don't publish it. So prospective clients, your firm, everybody else doesn't necessarily know that you've been reprimanded, but with a private reprimand by the bar. So of course that's what you want, or a public reprimand. Now, what's the difference between suspension and disbarment? What is the difference between suspension and disbarment? Well, disbarment you may think is permanent, but it's not necessarily. Occasionally I will see a state bar permanently, like once and forever, disbar a lawyer for something really horrific. But normally I see disbarments for periods of 2 years or 5 years or something like that. Suspensions are usually shorter. Very common that you see a 6-month suspension. Very, very common. 1-year suspensions. Occasionally I see something that's a 2-year suspension, but most suspensions are 6 months to a year. So they're shorter in time, but the bigger difference is what happens when the period of time ends. And so if you've been disbarred, basically they have revoked your law license completely. And when your period of disbarment ends, you have to start from square one with, in Texas, let's say, the Board of Law Examiners. Like, you have to apply for a law license from scratch. You are almost surely going to have to take the bar exam again. I predict they're going to make you take the MPRE again, even though you passed the bar exam and passed the MPRE before. They're going to put you back to square one, like if you were a law student. But you're not even back to square one, because you actually have this uphill battle of convincing them that you've completely changed, that you're not the same bad apple that you were before when they disbarred you, that you've turned over a new leaf, you've reformed, you've converted or something like that. And now you're a good person. You're going to be good from now on. And you're going to have to seek readmission to the bar as a previously disbarred lawyer. And that's difficult to do. And they're definite. Are they going to hold it against you that you were a lawyer before and they had to disbar you? Yes, of course they're going to hold that against you. It's a big burden to overcome. Suspension, in contrast, if you've been suspended for 6 months, at 6 months and 1 day, you can go right back to practicing law. You don't have to file paperwork. You don't have to reapply. You don't have to take the bar exam or anything like that. And so, for example, if you're working for a firm and you got your license suspended, they basically can just treat you like an intern or have you work as a paralegal for 6 months and not be the attorney representing clients, or have you work directly with any clients or be the attorney of record in court or anything like that for 6 months. And then 6 months and 1 day later, you can do it. Or you get suspended, you're going to tell all your clients, by the way, my friend here is going to represent you for the next handle your case for the next 6 months, your representation. And as soon as your suspension is over, they pass the cases back to you and you can go right back to representing people and stuff. So it automatically essentially reactivates your bar license. Now, that may sound all great, but I do want you to keep in mind that we see a lot of lawyers get disbarred because they kind of were still doing a few things for clients on their cases while they were suspended. And so it's very tempting to do that. Okay, disqualification by the judge, which is what the last video and this video are really about. This is a remedy that's used for conflicts of interest. And why am I talking about this so much? Because even though conflicts of interest is very serious, and it's the most heavily tested subject on the MPRE, it's actually pretty rare that I see disciplinary actions by state bars for conflicts. They do happen, but by far, most of the disbarment, suspensions, and reprimands are over neglect of a client matter, or not being diligent in your representation, basically dropping the ball and not doing anything, or failure to communicate with the client. Like you didn't return their phone calls, or you didn't really tell them what to expect, or you misled them about the nature of their case and told them it would settle when you knew it was going to trial, something like that. And then a handful of things like mishandling client funds or not returning unearned, unused client funds that when the representation ends, and so forth. It's very rare that you see a disciplinary action over conflicts of interest. It does happen. It does happen. And I don't think a year goes by in any state where you don't get at least some of these, but it's not the most common. And state bar disciplinary actions in practice are not the main way the conflicts rules are enforced from a legal realist perspective. Instead, they're primarily enforced through disqualification and civil legal malpractice lawsuits by the client. And so this in itself can have really serious consequences. Some rules can also be enforced by contempt sanctions by the judge. By the way, disqualification is only going to apply before a tribunal. So if you're drafting wills or for people who are doing real estate transactions, disqualification doesn't happen to you. There's no judge that can disqualify you because you have a conflict. Malpractice can, but disqualification doesn't. So this is only in litigation. Sometimes I'll see disqualification for something that's a conflict sometimes with a former client, but what's really the concern is the violation of client confidentiality. So those rules are confidentiality and conflicts of interest come up with disqualification. Contempt sanctions. This is, for example, where the judge gets really mad at you for not turning over evidence, or for submitting falsified evidence, or for talking to jurors inappropriately, or you using disruptive tactics in your trial to delay the proceedings or something, and the judge can just fine you or put you in jail for contempt. And so this is a separate remedy. It doesn't come from the state bar, but it can apply. Judges do have a lot of power to do that. And so when it comes to conflicts of interest, we're talking about disqualification as the main remedy and malpractice lawsuits by the client. Now, who has standing? Typically only a current or former client has standing to bring a motion to disqualify counsel on the basis of conflict of interest. There's a Fifth Circuit case from 1976 in Ray Yarn Processing. That's one of the most cited cases about this. And so I'm going to give a quick example. You're representing two criminal defendants in a case, and the prosecution can't, and you have a conflict of interest because they're both thinking about blaming the other one at trial. The prosecution can't ask the judge to disqualify you. But keep in mind, the judge can always do stuff on their own motion, and sometimes judges are going to do that in criminal cases. Another situation is you're representing, some of our conflicts were because you're representing co-plaintiffs in a lawsuit. Well, if the defendant has no relationship with you, they can't object to your conflict of interest between the group that you're representing together. But what more often happens is someone that you used to represent, you've withdrawn from representing them, and now you're representing somebody who's an opposing party to them. They're going to have standing to ask a judge to disqualify you. You don't have to know these cases for my exam. These are from the annotations on Westlaw, and sometimes they give little illustrations. I'm just mentioning them by way of illustration. So we have this Barnocchi case from Georgia in 2005. Typically a non-client is going to have to show such a serious violation of the rules that calls into question the whole administration of justice and the proceedings, right? So the only way to get around the standing requirement is if the other side is saying, this person has such a ridiculous conflict of interest that it is, we're probably going to end up having this all adjudicated a mistrial anyways, even though I don't have standing. And so that's worth bringing up. Please note that a violation of 1.7 does not always result in disqualification, particularly if the firm has implemented a screening measures to screen out conflicts and the complaining party cannot show it was harmed. As I mentioned in my previous video, disqualification is a drastic remedy that's really going to be prejudicial to your client, and it's probably going to generate a malpractice action and could and so forth. And it delays the proceedings because a new lawyer, of course, is going to ask for a postponement while they get up to speed. And so, so this is almost like a good faith exception to conflicts when it comes to the disqualification remedy. It doesn't mean you won't be able to sue for malpractice, like the client won't be able to sue you for malpractice, but the judge is going to ask some things like, was the conflict foreseeable, or was this such a remote, attenuated, unlikely thing that we think the lawyer really was acting in good faith, had no reason to discover this? Maybe the client lied to you so that you wouldn't and kept you from discovering your conflict of interest. And now, to your horror, you've discovered it after the representation is underway. These things can happen, and the judge will consider that. The other thing is that sometimes if your other side is, if the side moving for disqualification is engaging in strategic gamesmanship, and so they know early on, immediately, that there's a conflict, but they decide to wait and move for disqualification on the eve of trial, on the morning of trial, let's say, or the day before you're supposed to pick a jury, just to maximize the inconvenience to your current client and create as much trouble as possible. Judges don't like that. They kind of see that as an unclean hand situation. Wait a second, you knew about this conflict 6 months ago or 9 months ago or a year ago, and you didn't object to it until just now, so that you could maximize the harm to the other side. So therefore, that could be a factor in deciding, I'm not going to disqualify the lawyer. And so that's it for now about disqualification. We're going to have some comments to talk about disqualification later on in the model rules, but you need to know about this remedy because it just kind of mentions it in passing without really defining it or explaining it.